signed the last legalization program for undocumented immigrants in 1982. IRCA, the Immigration Reform and Control Act, was Ronald Reagan, 1986. So, Ronald Reagan, viewed as one of our most conservative presidents, signed that last legislation. We have today a situation where bipartisan support for progressive immigration reform has virtually evaporated. It has to come back. For us to have a chance of moving forward progressive immigration reform, it has to come back. In the meantime, as you know, we have a president who has elected, with some pressure, to put in place deferred action for childhood arrivals and deferred action for parents of Americans. The latter program has been prevented from being implemented by federal court. Latest development only a few days ago is that the Fifth Circuit Court of Appeals, the Court of Appeals right above the district court, has upheld the preliminary injunction issued by Judge Saenz in Texas to prevent the DACA from being implemented and the expansion of DACA from going forward. Final word. We've intervened in that case. At the same time the Fifth Circuit made that decision, they also overruled Judge Saenz, who said that Maldef's clients could not intervene as parties. We are now being intervened as parties. We will be participating in the case with the federal government to defend the president's right and authority to put deferred action in place. Now I'll conclude with this. I know I've been saying this for a while, but I'll conclude with this. The Constitution and the president's executive authority clearly supports what he sought to do. Still has in place a DACA program from 2012, and everyone who's eligible should seriously consider making an application. It gives you protections, it gives you work authorization. But his expansion of DACA and his introduction of DACA also squarely within his powers. I want you to think about it this way. Everyone acknowledges that the president has the right of prosecutorial discretion. Supreme Court justices on down, everybody acknowledges that when you are in a position of enforcing laws, you have the right, indeed you have to, engage in discretion, because it's impossible to enforce the same way on everyone. In order to engage in meaningful prosecutorial discretion in the context of immigration in 2015, the president has to have the authority to give clear guidance to all of those who work in the system. Otherwise, he would not have the right of prosecutorial discretion. This is not the 1800s, when perhaps it's conceivable the president could make individual decisions on every immigrant's case and decide where to exercise prosecutorial discretion. Obviously, that's not realistic given the numbers that are involved. For a modern-day president in the 21st century to exercise meaningful prosecutorial discretion, he has to have the ability to quickly put in place guidance that must be followed by those who work for him, all the way down to the rank and file officers. And that very logical principle is what the state of Texas and the other states are challenging. Ultimately, I believe, and I think I'm joined by most of those who have some learning and knowledge in this area, ultimately, the president's authority will be upheld. The question is a matter of time. Time is critical because of what I mentioned previously about the existing obstacles to enacting congressionally the ultimate and most important permanent approach to the issue, progressive immigration reform. So with that, I know I've gone on and on, probably bored you to no tears, but at least that I can see. But I would be happy to answer questions about immigration, about Maldef, about civil rights concerns, and again, I want to conclude before we do Q&A by thanking the College of the Book program for including me in this important work. So the DACA program that was announced in 2012 is not affected by the lawsuit as well, at all. So if that's what you applied for, great. Unfortunately, There are lots of delays that we're trying to get the administration to work on in adjudicating those applications, but it should move forward smoothly. The expansion that the President announced almost exactly a year ago, and the separate DAPA for parents of Americans, is what the court has prevented from moving forward. So those programs, folks can apply for them. If you hear anybody, notario or attorney who says you can, they're misleading you. Because those programs are not being implemented right now. The pre-existing DACA program from 2012 is still in existence, and everyone who's eligible should consider applying. But these new programs can't be implemented yet. Our intervention means that instead of just the states versus the federal government, now the clients that we represent, who are 3 mothers in Texas, who would be eligible for DAPA if it were implemented, they're now in the case. So they join in defending the program with the President. So the President's lawyers make their argument, we get to make arguments on behalf of our clients and the other potential recipients of the DAPA or expanded DACA. That's important because as much as I appreciate and applaud the President for what he did by announcing expanded DACA and DAPA, sometimes the perspective of the government, keep in mind it's the same government that has deported more people than any other administration in history, they have a different perspective on these issues than those who would be recipients of the deferred action. So now those voices will be heard as the case moves forward. Because the Fifth Circuit upheld a preliminary injunction, the federal government now has the right, and they've announced they will seek review by the U.S. Supreme Court. And it's a question of how quickly the U.S. Supreme Court will accept the case and then decide the case. If it moves quickly, it would be decided before June 2016, because that's when the current Supreme Court term ends. They go term by term. They take the summer off, they work between October and June, everything they start in October has to be done by the end of June, every year. So if it moves quickly enough, and it's a close question whether it can move quickly enough, it would be decided by the Supreme Court by June of 2016. If they can't move it quickly enough, then it would not be decided until the next term, meaning no sooner than late 2016, but by June 2017. The problem with that is there would be a different president at that point if it's not decided this term. And because it is a president's exercise of prosecutorial discretion, the new president has the authority to change the deferred action, both DACA and DAPA. Now, you should know that I think most presidential candidates have been pretty clear about what their view is on whether they would support and extend DACA and DAPA, or whether they would seek to reverse it. So I think it's pretty easy. I work for a nonprofit. One of the legal rules for nonprofits is we can't express a support or opposition directly or indirectly to any candidate for office. So I can't tell you, but you can very easily verify what every candidate's position is on that issue. By the next president? So the question is, is there a possibility for those programs to be denied? In theory, yes. Okay, because the president's discretion, this is why we need congressional legislation to make it the law that can only be changed by Congress. This is a program that's within the president's authority, so a new president could change those practices. I think there would be tremendous pressure on any president to at least not reverse it for those who have already applied for DACA and received it. Now, as far as choosing not to implement the new deferred action for parents of Americans or the expansion of DACA, I think it's more likely that a president would be able to do that. But again, the candidates have different views, and you can very easily, I think, figure out online what their various views are, but they would have the authority to change it. So the question is about the new law in California on professional licenses for immigrants. One of the reactions to Proposition 187 21 years ago, regrettably, was that the federal government changed federal law through 3 different laws. One of them was a portion of what was called the Welfare Reform Act in 1996. That title, it's called the title, the section of the very, very long bill, dealt with immigrant eligibility for various state programs, including like assistance programs, assistance, prenatal care for undocumented mothers, for example, in California. But it also included in it eligibility for professional licenses. Okay? And that law established as a rule across the country that there is a presumption that undocumented immigrants are not eligible for professional licenses. However, that federal law said a state can enact its own legislation to change that rule in its state. But the federal government said it has to be a specific law that specifically provides for undocumented immigrant eligibility, and it has to be paid for by state money, not federal. So the new law, which is enacted now, it's been in effect this year, so it was enacted in 2014, finally establishes that in California, everyone's eligible for any professional license. Their immigration status does not play a role in their eligibility. So it now opens up all kinds of law licenses, medical licenses, business licenses that previously were not open. It opens it up, and immigration status is not a criterion at all for whether you can receive such a license.
For immigration, not only the issue, so it would not be immigrants must be criminalized or diagnosed in Africa because they do apply for Is there anything to prevent?
Okay, so I was answering a question about professional licenses. There was also legislation that provides driver's licenses. Okay. There are protections in that law for the information that is provided. There is no such thing as a complete protection. Okay? No such thing as a complete protection. But I can tell you as much protection as possible was put in that law to prevent the federal authorities from accessing it to get information about where immigrants may be. Okay? And we are continuing to work to do everything we can to get the information that's collected, for example, destroyed. But I have to say there is always a theoretical possibility that information access. I would say it is very unlikely. As much protection as possible has been put in place. And my advice would be that having a driver's license and being able to drive without fear is probably very valuable. And people have to make a decision about the risk. And I think the risk has been as minimized as possible, okay, versus the gain of having a driver's license and an identification, basically. The identification, as you may know, says that it can't be used for federal purposes, but it's still valuable identification and the ability to drive without being harassed about not having a license. I think the driver's license checkpoints have largely been eliminated, but if they were to be put in place again, or if you were to be pulled over for any kind of reason and not have a license, as you know, there are consequences for that. It can be costly. So it is a balance, but the protections have been made as strong as possible, and folks are continuing to work on that issue.
I saw on the website that there's an office experience, and an individual or office or council immigration stuff cases, or
So actually, MALDEF, our headquarters is here. So I, as a national president, am here, and half of our staff is here. We have regional offices also in Chicago, San Antonio, Texas, where we were founded, and Washington, D.C. We have a satellite in Sacramento, and a one-person office in Atlanta, Georgia. With respect to your question, we generally don't do individual cases. We have limited resources, and we look for cases such as intervening the Texas versus United States case about DACA and expanded DACA. We look for being involved in cases that are going to set a precedent that have a larger impact. So we're not an individual service provider. There are agencies that provide legal services on an individual basis, including some in the building that we are, So if you were to call MALDEF or someone were to call MALDEF, we would help you to find those other agencies that do individual services for free or very reduced cost. We generally don't do that. We're involved in looking at human rights issues, trying to find the cases that would affect large numbers of people.
Is there a way that just the same way that we did with Barcelona firewall and started with the 85 volt, is going out as a dream now, that's we don't have like that. Is there any way that the community, students, and everyone else just make the same pressure that we did with the 85 volt to pressure now when they got one in the other programs?
So, I was a big fan of Fireball, but I want to make clear that it was actually organizations that came to him, including others, with that approach. And actually, we did it in Texas before California. I never like to acknowledge that because actually California proposed it first. Texas got it enacted first, whatever. But political pressure was very important there. Political pressure was also very important in convincing President Obama to initially implement DACA in 2012. Prior to that, he was telling people publicly and privately that he didn't have the authority to do it. Now, he was wrong, and he was ultimately convinced largely through public pressure, much of it from those who would be eligible for DACA, to do it. Okay, so political pressure, public pressure is very, very important. So to answer your question, it's very, very important to engage in that kind of continual pressure on state and federal office holders and potential office holders to secure the programs like DACA and DAPA that are within the discretion of individuals like the president. So I wholeheartedly believe that we must continue that pressure, even in a state that's doing as well as California, to continue to do more. So, and California has done more. I'll tell you one law that's taking effect January 1. Okay? It's the first state, and it was a MALDEF-sponsored bill. The same bill was vetoed by a Democratic governor 10 years ago, but it was signed this year. And it is a bill that puts into California's basic public accommodations anti-discrimination law. And that means the law that applies to all business establishments. So any business establishment, it tells them when they may not discriminate. As of January 1st in California, it will specify that businesses may not discriminate on the basis of citizenship, language, or immigration status. So, no business can discriminate against someone because they are undocumented. That means asking them for papers. That means asking them, are you here legally, before providing them with services or business. They cannot do that anymore. First state to do that, very important element of immigrant integration. And if you ever become aware of a business establishment engaging in that kind of discrimination, that's the kind of case that I'm all that we want to establish, because hopefully it sets a precedent that other businesses see, oh, not only will the law say I can't do this, if I do it, I'm going to get sued, I better change my practices. Okay? So that's another more recent step, and there are more being proposed to increase California's immigrant integration model for the rest of the country. And that comes also through public pressure. Yeah.
I got two questions. So you said that they can't discriminate.
Speak up.
So then, how does that affect Social Security? And then what about non-citizen Social Security? Do they get benefits somehow? Like, let's say they're 64 and they have non-citizen Social Security, and then can they retire or something?
So the law that I was describing was for business establishments, not government. Unfortunately, the government has different rules that apply. Federal government has rules for Social Security because Social Security is a federal program. Okay? So undocumented immigrants are not eligible for any Social Security benefits. Okay? Citizens obviously are eligible for a number of different benefits if they become disabled or if they reach the retirement age, which is inching up from 65 to 67 as time goes by. And lawful permanent residents, okay, have eligibility for most Social Security benefits, particularly the ones related to their work. Okay. That also relates to the 1996 law that I described earlier that restricted states' ability to provide professional licenses and other services. Okay. That law also applied to state services. So unless the state decides that services that it provides at its own cost, not federal programs, states can decide whether or not to make undocumented immigrants eligible. I mentioned prenatal care because back in the 1990s, that was an important issue of contention. Governor Wilson wanted to end a program that provided prenatal care to mothers regardless of their status. That federal law made it possible for him to end that program. Now, fortunately, there was a legal challenge that prevented it from going into effect until there was a new governor who signed new legislation compliant with that federal law, so that still prenatal care services are available in California regardless of status. But the state has to make a decision to specifically make undocumented immigrants eligible for those services.
Thank you, Laura. I'm going to the first generation of DACA. And my question is, will you be able to apply for any other program, that's in your law? That they have, you can apply for that. Should I be able to apply for any other, visa, like you mentioned,
You mean, could you apply for adjustment
yeah,
that if you were eligible for it today? Okay, the answer is yes. I'm not positive, I'm going to check, but I believe the answer is yes. Now, keep in mind that with immigration reform, the rules will change, right? So if there's immigration reform and there's new forms of adjustment, it's all going to depend on what that new legislation says. But if you're asking today, that becomes a basis for your adjusting to lawful permanent resident, I believe that you can do that, but I'm going to check. So there's no current program in proposed legislation. There were provisions that were proposed that would have allowed certain of those who were removed within a particular period to return. So the question is really what will be in the legislation once something moves forward and is enacted. So all I can say is there certainly was consideration of proposals or programs that would recognize recently removed folks' right to come back. Unfortunately, without new legislation, we're left with the laws that are in place today, so yes.
In the recent years, many other marginalized groups, such as uninsured and LGBT, achieved their changes through court victories and the legal law. Do you think such option is available for immigrants to advance immigration costs and to achieve such a similar changes?
Is there a court avenue to achieve changes to federal immigration law along the lines that the LGBT community used the court system to obtain marriage equality, for example? And the answer, unfortunately, is I don't see an avenue to challenge and change federal policy today, other than in marginal ways around detention, where I think there are serious issues about whether current detention conditions, particularly for subpopulations, are constitutional. I think there are other issues about due process in the immigration court system that may be subject to court challenge. But as far as dealing with the major issues of legal protections for the undocumented, getting them some form of status, and the question of changing our current system of determining who's allowed in, unfortunately, because of plenary power as recognized by the Supreme Court to date, I would have to say that's unlikely to be achieved through court, but far more likely to be achieved through political pressure on the Congress and the President, whoever they may be, to change the laws legislatively. I'm not willing to foreclose it entirely. You never know how you can potentially develop the law, but right now I would not say that's the most promising avenue, other than with respect to some of those more detailed, specific issues, but not the big picture issue in the same way that marriage equality was addressed. So you asked about minors being detained. So we have challenged through complaints with the federal government the way that minors were being detained. We continue to advocate for ending all family detention. We advocate behind the scenes and through public statements to try to have those minors treated fairly. Unfortunately, some of the proposals to change for the worse the way unaccompanied minors are to be addressed in the immigration system have gone away. You may remember a year ago summer, the reaction to the perceived increase. It was an increase, it was a little bit over-exaggerated, it was relatively, but the increase in unaccompanied minors crossing the border in Texas primarily was people from the president on down were proposing streamlined procedures, ways of deporting minors more quickly. Fortunately, those changes were never made, and so far nobody's talking about them again, which is a victory. We still have work to do, and we continue to work with others to try to address the detention issues, and particularly to address the issues of legal representation. Because whether or not a minor gets legal representation in immigration court plays a huge role in whether they're likely to get the relief to which they may be entitled or not. Because most of them have a strong claim to asylum, but if they don't get legal representation, their chances diminish extremely. So working on getting them legal representation, changing the conditions of detention is work that's ongoing. Not solved yet, but at least it wasn't made worse from what was being proposed.
I have a question about the justice situation. Is there any law protecting the government or the customers of justice or private residents that own land? Because I've seen documentary on videos and I've seen is there any protecting for human rights?
So private individuals can't shoot people just because they're trespassing on their land. That there have been abuses, but in many of those cases, those landowners have been sued, while deaf and others have sued them, to impose great costs on them, and in most cases they then change their practices of intimidating, shooting, beating those who they find on their property. So there is protection in law, but you have to enforce those protections. And for private landowners, the enforcement mechanism is either law enforcement, which unfortunately is not going to be aggressive in those states, or private parties suing them and then imposing a cost on them, so they will choose to refrain from conduct that will be very costly to them. So that's what's gone on. Now, with respect to, I thought you were going to ask me about Border Patrol, which I think is a more troubling issue that falls in line with a lot of the police abuse issues that are being discussed in very positive ways, though not yet where we need to be across the country. There is abuse by the Border Patrol. There are constitutional violations, and those constitutional protections extend to those who are entering the country regardless of their status. You are not allowed to use excessive force if you're a Border Patrol agent, the same as any police officer. But as you see with the police cases, it's not always easy to prevent those things from happening unless you put in place strong policy. Unfortunately, one of my criticisms of this administration is they have not put in place strong policies to protect against violations by their own rank and file officers, whether they're ICE on the interior or the Border Patrol. And that's a great disappointment because it's the very same federal government that goes to local police departments, including LA's 10 years ago, and puts in place the right kinds of controls through a court settlement that changes practices. LAPD was much, much better for a long time. This year, I can't tell you what's going on, but prior to this year, LAPD had dramatically improved, largely because the federal government came in and put in place the strong practices to change a culture that allowed too many violations. It's always been inexplicable to me that the very same federal government that does that to local police forces will not take the same learning and apply it to its own ICE and CBP officers. And I can't explain why they won't do that except political will. citizens immigrate there.
Thank you for coming. I'm a survivor of Pete Wilson. I was 1992 walkout for Proposition 187, and I lived in Arizona, and I survived Jan Brewer also. So I went through both of them, so I know exactly what you're talking about. And my question to you is about immigration. You gave us your numbers on like Europeans and the Western part. How much of that do you think is going to be an issue to change, whether it's in the country itself or in California, because of illegal narcotics being transferred into the country? Because you did say a lot of these people have been abused. I'm thinking some of these Border Patrol agents are fearful of their lives, so some of that abuse comes from that fear. It shouldn't happen, but my question is, how much, and do you think we will be changed in 20 years? And how much of that is going to be affected because of the transportation of illegal drugs?
I could give an entire speech about that. I think the answer as a practical matter is unfortunately it will influence policy setting. I don't think that it should. I think that we are not taking a very well-informed view of drug trafficking and immigration and how they relate. And the problem of drug trafficking largely relates to demand in this country and our failure to address the issue of demand in a successful way. And that's largely because we have used a punitive approach that has failed. Not in every instance, but certainly you look at the system and it's failed. So we are not addressing the issue of drug trafficking from the standpoint of demand within this country and putting in place effective policies and practices to address that. Second, and this is a deeper issue of immigration, we in this country, perhaps uniquely in comparison to other countries, fail to see immigration as an international issue. We view it as a domestic issue. Whatever we think is best within our borders is all that we, as policymakers in this country, think about with respect to immigration. But in fact, immigration is an international issue. And there are consequences for what we do in our immigration policies in other countries. So similarly, our policies can drive immigration to this country. We know that historically and today. I'll give you the best example that comes up from the unaccompanied minors. For many, many years, we routinely removed folks who had convictions after they served their time, and sometimes before they served their time. And if they served their time, they didn't really achieve any rehabilitation because that's not, unfortunately, what our prisons are designed to do. They're not designed to rehabilitate. So you would have folks who are unrehabilitated who would then be removed from the country and sent back to the country of origin. Now, many of those were in Central America. What we effectively did was took a gang culture from the United States and exported it to other countries without any consideration that that might be the consequence of our immigration removal policies. And then that contributes, not entirely, but in part, to conditions that then drive minors to reasonably fear for their lives and be driven to this country. So we fail to recognize that our own immigration policies, because we didn't consider the impact on other countries at all, then have ripple effects on this country. And our continued refusal to see immigration as anything other than a strictly domestic policy issue is a major problem to having rational discussions about issues like drug trafficking and the people flow across the border along with the drug trafficking. So unfortunately the answer is it is going to infect policy discussion, and that's unfortunate.
And do you see that changing in the next 20 years?
Well, I'm trying to be an optimistic guy, so yes, I think that if people start to raise these issues, and they are raising these issues, and they come to the attention of political leaders, and those pressures are manifested in votes, then I am hopeful that it could change in the next 10 years. But if we don't take those steps and change the whole dialogue around these issues, then unfortunately immigration policy will be poorly influenced by some of those issues. Yes.
So I would like to know for the future if it would be possible for immigrants, the immigrant children are not allowed to be U.S. citizens, or are not considered to be U.S. citizens because
Those who are born here?
yes.
So, birthright citizenship, as it's called, is in the Constitution. So no matter how much these presidential candidates, again, I won't name them by name, they tend to be grumps, but prevent people from proving their citizenship. You may be aware that the state of Texas now, and it varies county by county, but is making it difficult for a mother or father whose only identification is matricula to go and obtain their child's birth certificate. Now, the reason they're doing it is if you can't obtain your birth certificate, then it's difficult for you to prove that you have citizenship. You know, that's already been challenged in court. We are also looking at a challenge of it because the challenge that exists has not succeeded so far. So I think that will be stopped in court, but there will be recurrent attempts to try to do that, prevent people from proving their citizenship. But birthright citizenship is secure unless there's a constitutional amendment.
For example, the parents are deported and they decide to take their children with them. Will the children not be able to return to the United States because their parents were deported?
No, if their children were born here and are United States citizens, then when they become adults, they have the right to return.
Because I have a cousin who was, her parents were deported and now she can't enter the United States.
Was she born in the United States?
Yes.
Well, that's not right. If she has proof of birth here, she's a U.S. citizen.
Yes, because my older cousin, he's able to return to the United States, but she can't.
Is she still a minor?
She's still in Mexico. She's trying
Is she, what age is she?
Excuse me?
How old is she?
20.
That's wrong, and she should get some legal assistance because if she's a citizen, she has a right to return. Absolutely right. There's a question about minors not being with their parents and about parental authority that arises if they're under 18. That's the whole question. But a citizen still has the right to be here. It's not a divorce per se, but you could go through legal processes to change parental authority and shift it from parents to someone who adopts them. Effectively, it's not easy.
I have a question about the conditional presence waiver. I know there was some suggestions to expand the eligibility for that waiver. They were not like in July, supposed to be the time period was by September, end of September, but there has nothing been issued on that question yet. Do you know what?
So, all I can tell you is that unfortunately the administration often makes announcements long before they're ready to implement things, and we have raised this concern with them, and we have urged them to be quicker about putting in place measures that they announce publicly to full fanfare, because it has effects on the public, and people can be misled about what's available and what's not. But for political reasons, all presidents, no matter who, like to make announcements publicly, even if they're not actually ready to implement what they talk about. And there's no legal way, unfortunately, other than just pressure. There's political pressure. There's no legal way to force them to implement what was announced.
How does extraditing work? Extraditing, they don't want immigrants to lie to
You mean people who fled?
like people who crime or wanting.
Well, they extradite them to the United States because they want to punish them here. Unfortunately, often that means being able to impose a death penalty because most of the rest of the world, with notable exceptions, doesn't have a death penalty. So it's designed for retribution.
So once they extradite here, they let like the case and they beat it.
Yes, unfortunately. There are lots of crazy things in our policy the way it works today. Yes. Yeah, I don't think that the reason folks are confident that we won't deport 11 million is about politics, because unfortunately there are folks beyond the individual that you have in mind who argue that there should B, no tolerance and everyone should be removed. I think the reason that people are not afraid of that happening has more to do with practicality, the ability and the cost of actually removing 11 million people, many of them have been here over a decade and longer, is just astronomical. And that's the difference between Dominican Republic and here, it's the size and the cost of engaging in these really unjust acts, right? I don't think it's confidence, unfortunately, that we wouldn't have political leaders who would advocate these crazy policies. It's that it would just be way too costly to implement them. So I think that's why there is a level of confidence that a solution that involves removing all 11 million undocumented people is not viewed as likely.
More about the money, but if we're just using the money, nobody did anything for the
That's-
and it's cheap for them, like you said.
No, that's why I don't think anybody has confidence, unfortunately, that there are not still going to be these irresponsible politicians who are going to advocate for crazy and unimplementable approaches. They will, and they will get support. Now, I don't think ultimately that's going to get them elected president, unless I'm misreading the electorate, and in particular, unless I'm misreading the levels of participation from young people and people of color and naturalized immigrants that I hope to see in November 2016. So I don't think it's going to get them elected president, but that crazy stuff is going to be out there. And they're going to seriously circuit. But I think the confidence that it will actually be implemented relates to cost and practicality.
I just have a question about the Latino students. So in California, you can attend high school here for 20 years, you can attend college. What about people who live here, let's say, 15 years and adults have never attended college here, and they don't have papers, can they attend college?
So the reason that AB 540 was enacted the way it was, to say you had to attend high school for 3 years here and graduate, was because of a federal law. Again, in the aftermath of 187, there was a federal law enacted in 1996 that basically said to states, and it was a reaction to what California was doing, considering doing. It basically said you can't provide in-state tuition on the basis of residency to undocumented immigrants unless you provide in-state tuition to residents of every other state. So it effectively said you can't, based on residency, provide undocumented immigrants with lower tuition, or else you have to eliminate the whole notion of in-state versus out-of-state tuition. So the law was specifically crafted not to be based on residency, but to be based on concluding 3 years of school, high school here. So unfortunately, it does potentially leave some people out. But I do know there's no age limit. So an adult could go to high school for 3 years, even if they completed it elsewhere, and be AB 540 eligible. But unfortunately, it had to be written that way because of the federal law.
What's the process problem for a student from Mexico trying to come to get education in one of the colleges in university? Because I heard it's also bad. It's better if it's actually the same process where you have to go to Spain and you have to accept it. So you could also say that you have a line or they accept someone.
So student visas are not permanent resident visas. So the quotas that I described don't apply. So, however, there isn't a discretion process involved in student visas. I'm not an expert on that, but I would not be surprised if there were differing standards applied to different countries, right? Based on the adjudicating officer's conclusions about likelihood of compliance with visa conditions. So, unfortunately, I'm not an expert on student visas, but it would not surprise me if that was the case.
Yeah, you said that we couldn't discriminate, right? I guess this new law for jobs.
Business establishment, no, not for jobs. Let me be clear, federal law governs jobs, okay? You have to have work authorization under federal law, and state can't change that. The law that I described is for business establishments discriminating against customers or folks coming in to receive, to pay for services or products, or to use the, whatever it is, theater or the like.
So it is
So NAFTA does not affect the work rules. It does not affect labor particularly. So our work rules at the federal level were established in 1986 by the same law that was the last legalization program put in place by Congress and signed by President Reagan. There was strong opposition to the employer sanctions that were a part of that law. That ultimately was opposition from civil rights groups because of concerns there would lead to discrimination, as it did. But it was unfortunately included in the law as a compromise to get the legalization program. It does require, as I'm sure you all know, that every employer on your first day of employment verify your eligibility to work. Now that's all they have to do. They're not supposed to be rechecking people's authorization unless there's an expiration date on their authorization document. They're not supposed to be asking for multiple forms of proof of authorization, which also happens. That is illegal under federal law. But the federal law was established now in 1986 that requires every employer, okay, so there are exceptions. Independent contractors are an exception, very complicated area, but they are an exception, usually for casual